on, then it starts, it blinks.
Well, good afternoon. I'm going to go ahead and call this meeting to order. Today is Monday, April the 29th, 2024, and we're calling the meeting to order for the Tennessee State Board of Accountancy. As required by notices, notice of the April meetings of the Tennessee Board of Accountancy, including date, time, and location, has been properly noticed, and copies of the agenda were posted to the Board of Accountancy website Tuesday, April 23rd, 2024. Individuals who wish to make public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on a provided sign-in sheet or by placing their name in the chat box online. The public comment period will take place at the end of the meeting today. Today's meeting consists of the board's 4 committees and their various agenda items. The full board meeting will take place tomorrow, April the 30th, beginning at 8:30 a.m. I want to welcome everybody to our new tech center. This is pretty impressive. I have been told that only 4 of us can have the button red at the same time, or else the 5th person can't get on. So everybody remember, as you get through speaking, hit your red button and get off. And then that way we'll have room for people to jump on and off. That I think they refer to as toggle on and off, if I'm correct. Also remind you that if everybody would check their cell phones immediately and just make sure you're on silence, so we won't have any issues during the meeting. And with that, we will go over to our licensing committee, and Janet Booker Davis, you're looking great right in front of us. You don't have to look around the room. You're looking very sharp with that background too. So welcome, and you're up.
So this is great technology, and I could actually work it. So that was even better. The licensing committee has one action item on the agenda today. And that item is a request for approval of a course for the upper level accounting by a CPA candidate as well as the University of Memphis. Both of them made this request to the board to review the Cruz School of Accountancy course, Accounting Course 300 for upper level division accounting credit. This course, I believe, has previously come to the board for review, for approval, and that request was not approved previously as acceptable under Rule 0020.021A-117. But the candidate and the University of Memphis, as I said, each have submitted their requests for another review. And you all received information in the pre-meeting material outlining their request letters, the syllabus for the course catalog listing the course requirements of an accounting major, as well as relevant information on the rules related to how we might approve this course. The relevant rule 0020-02-.02 is the rule that determines what course content could count towards accounting requirements. And then there's also another rule that gives some other criteria where we might consider approving a course. And that rule is 0020-02 dash 0.021A18B. And from my reading of the information, that seems like where we might give some consideration under that ruling. So for the board's consideration today, we're asked to approve the request for this career development for accounting majors to meet upper level division course requirement for any candidate seeking CPA licensure in the state of Tennessee. My initial review of the information that was sent in left a few questions that I had, and I had asked Wendy to reach out and ask what percentage of the course, particularly related to that practice set, was reflected. It wasn't real clear to me from the syllabus. And so she did reach out and ask that question. And also she asked if the course was still being offered. And we did get a response from one of the professors at the school indicating that at least 20% seemed to be a good estimate of the content of the practice set related to that course. And that the accounting course 3000 had been replaced by accounting course 3100, foundations of accounting. And they indicated that the course was similar, both included the practice set. And the new course also included the first 5 chapters of intermediate accounting and several Excel exercises. And I think you all got a copy of this information as well. And it seemed like the old course included, I guess it seemed like what probably would have been included in the first 5 chapters of an accounting course. And Pam, I'm sure you will want to weigh in on this as well, given your expertise. I guess I was kind of torn a bit as to whether or not it should be approved, and just will open it up to discussion for the committee to hear what others might have to say.
Janet, this is John. I need to recuse myself from participation in this discussion, and just heads up to Karen as far as voting.
Okay, thank you for letting us know that.
May I start with a point of clarification? Has this board considered this course, or did NASBA reject it for the candidate?
The board has not seen this before. It was NASBA, so more at a staff level, it was denied based on the rule and the subject matter content.
Okay. And
Okay, thank you for that.
my understanding is that NASBA, I don't know, sometimes they're not as familiar with our rules as we might be. And I'd like to point out, and maybe this is my educator's bias, but when we passed these rules, we discussed them at length. And as I recall, Lipscomb actually sent a letter and as I recall, said something like they hoped that the board did not get into the business of curricular design or something like that. In other words, we do look to the schools to design their own curriculum. With that said, we have a set of guidelines. And when I first saw this, I wrote Wendy and said, in my view, this is borderline if you just take what, my casual perception is of upper division. And yet, I do think it meets our own rules. So for one thing, some of it is communications, and our rules say that communication is okay as a topic in an upper level course. It does require both principles courses as prereqs, and generally in the curricula that I'm familiar with, if something requires the first 2, then you're going into upper division because those first 2 are often sophomore level courses, so you'd be moving into junior. I did not look up and see whether the new course teaches the first 5 chapters of intermediate in lieu of their being covered in another separate intermediate course, but that one sounds solid to me. This one, they are applying for sure what they learned in the 2 principles courses. And again, our own rules say application of financial principles. So I think if you are reading our rules fairly strictly, that it fits. And I don't know how much the board wants to provide input, for future whatever, but I'm okay with it. But I did, like you, have questions and had to go back to the rules and the syllabus, et cetera, to make sure I could find evidence that supported my opinion.
May I make a comment, please? Is this one?
Sure.
Yeah, I looked at the rules that were provided to us in the package, and it looks to me that under Rule 20-02.02 B1, and I'm assuming this is all the criteria that a course has to follow. B1 says, develop the skills required to apply the knowledge attained, including skills in communications, critical thinking, research, and analyses. And I think that, to me, this course definitely did. I mean, the bookkeeping part of it, I think you said was 20%, perhaps? Okay. The other part of it, they're talking about how to set up a LinkedIn account, how to communicate, how to eat a business lunch, which that's lost on a lot of people these days, a lot of kids these days, is how to actually converse at lunch and how to have a business meeting, shake people's hands, look them in the eye. So apparently this is what this course, that's a lot of this. And I think there's a lot of people, of any age, that lack a lot of those skills. And to me, I thought, as soon as I read that rule, I said, well, God, that seems to apply. And then I had something else on that. So the course syllabus says the practice set, which is, I guess, the bookkeeping part of it, has been designed to provide students with experience in the practical and technical skills essential to accounting through the completion of a 1-month accounting cycle for a fictional business. I remember that course in college, whatever, and that was undergraduate. And I remember it being so essential and difficult, for someone who'd never done a set of books before. So assuming they complete this and turn it in and they pass this, they got to get the debits and credits right, I'm assuming. I think this class qualifies, in my opinion, so.
Okay. Any other comments?
Janet, this is Kevin. I'm not on the committee, but did have a question maybe that Wendy can answer. So NASBA did review this course, and they rejected it. Did they provide any color around that beyond what we received in the packet?
So if you were to review the rule closely, in that A18, so in 02AA, it lists all of the subject matter content that would qualify. And then in 18, it says other accounting-related content included in either the blueprints or as may be approved by the board. So I think what they were saying is it did not necessarily have enough technical accounting as noted in 1 through 17. And so that was their initial thought there, is that it doesn't meet the requirements. And in 18, the only way something like this could be approved would be if the board looked at it and agreed to it, which is kind of where we are today.
If you did not look at all the materials, look at the 11th page, which is of the licensing account 3000, ACCT 3000, PDF page 11. And that gives you the course objectives there. And I highlighted, become proficient in functional bookkeeping, demonstrate oral communication skills through practice interviews and class presentations. And the last one I'd highlight, learn how to use effective career communications, such as accepting a job offer, negotiating salary and other extensions, declining a job offer, and pursuing professional recommendations. mean, that's stuff you learn on the job after about 2 or 3 years, you know, and if they're teaching that in school, I think that's pretty phenomenal. Assuming they get all of that.
And those are covered, I think, under our rules, as you had indicated. Kevin, I think what Wendy said is how I interpreted it. In other words, the board listed courses that would be essentially pre-approved, and NASBA, we essentially instructed NASBA to kick it back to us if it didn't neatly fit into one of those. This is a mixture of topics, so I think it's not unusual that they kicked it back to us.
Well, the title of it is not that great. The name of the course is pretty vague. I think that's probably what did it. I mean, that's my opinion, but.
Yeah, probably.
Historically, we have looked at accounting education as a majority of the course would need to be technical accounting. And I think that's just a lot of why they said, we're not sure, the board needs to look at this. So, and I think you have every authority to approve it based on 18 and then B as to what you need to look at to determine if you're going to approve it or not, so.
Because B, I mean, it doesn't say it has to just be technical accounting. It can be a lot of other things.
I mean, not to get into hypotheticals like the Supreme Court recently did, but I mean, I remember taking in undergraduate a philosophy of logic course, where you had if-then statements and you had to reason it out and so forth. Now, that was in the College of Arts and Sciences. We weren't trying to qualify that as upper-level accounting, but in theory, it sounds like that might have qualified here under this provision, and I'm not sure that it should. And I think, like you, Janet, and you, Pam, initially, I mean, I had some misgivings when I reviewed the content, and they were mainly related to the fact that the practice set was such a small percentage of the overall course, at least as I could discern from just reviewing the materials that were presented. And I kind of came away saying, I'm not sure I would say this is upper-level accounting. But I guess I just appreciate the fine-tuning us onto, what does our language actually say? And I think that's what we have an obligation to uphold.
Wendy, do we have to designate whether we're approving this under the 18B part of the rule, or just give it our approval?
I mean, I don't know that we have to state that, but I think that's the consideration or the authority you have to approve it. If we didn't have that section, I'm not sure you'd have the authority to approve it. But because the board has the ability to review the course in accordance with the items in B, you have the authority to approve it if you think that it meets those requirements. But I don't know that you specifically have to state that in a motion.
So I guess the question I have is, if we were to say, okay, we're going to approve this course, does that automatically include the 3100 that's at the University of Memphis also, the way it was kind of purported here to be the next level? It's kind of basically the same thing that we now call 3100?
No, I mean, this is specifically for the 3000 course, and I believe they have revamped the program, likely to add some more technical content since this had been an issue before.
Okay.
Okay, anybody else want to make any comments or questions?
For the record, Janet is on the phone and John is recusing himself, but we still have 3 committee members in the room. So we do have a quorum on the committee to make a recommendation.
Thank you for that clarification. Any other comments, questions? If not, then can I make the motion to approve the request to accept the Accounting 300 course in the upper level accounting
3,000.
division?
3,000.
Accounting 3000, sorry. maybe I should restart again. It's okay. The motion to approve the request to accept the University of Memphis Accounting 3000 course to meet the upper division level accounting education requirements for any candidate seeking a CPA license in Tennessee.
So
Is there a
moved.
second? Okay. Do we need a roll call vote or how do we?
Maybe if there's any further discussion before we have the roll call.
Okay. Is there any further discussion?
I'm not-
Hearing none. Karen?
Janet Booker Davis,
Aye.
Pam Church,
Aye.
Brad Floyd, Rob Vance.
Aye.
All right. Is that all,
Okay,
Madam Chairman?
that's all. Yes, that's all our committee has today.
Well, thank you very much. Appreciate it. Good job.
Okay.
Now we'll go over to law and rules with our John Griesbeck, our chair. Mr. Chair.
Thank you, Mr. Chairman. We have two items on the Law and Rules Committee agenda today. One is application of the new rule from 18 to 30 months for conditional exam credit. And the second is to review the draft of rule changes to Chapter 0020-06 related to the peer review program. So the first one regarding the rule change, you'll remember that in May of 2023, the board approved amendments to the rules to move to a 30-month window to pass the examination and began the rulemaking process. That process is complete, and amendments to Rule 0020-01-.06 examinations are effective May 28th, 2024. The rule change expands from 18 to 30 months the time a candidate will be provided to pass all required test sections. Staff believes that implementation of the new rule requires discussion and approval by the board. You received background information from the staff in your preliminary board meeting materials. Staff has identified two options for implementation, either on a go-forward basis or to apply to anyone with active credit on the effective date. They're labeled as option 1 and 2 there. We also have in the materials other information relative to other jurisdictions and what they have adopted and or are considering adopting related to the 30 months. I'd like to ask Wendy to just provide any comments from the staff perspective regarding implementation to assist in our discussion. Her and Neil have talked about this quite a bit, I'm sure, and to help us sort as we go forward.
Thank you, John. And also, as a point of clarification, welcome to Laura, legal counsel today, and Taylor, who will help us in the disciplinary action report. Neil is on military leave today, so they have stepped in to assist us. So with regards to this particular rule change, when the rule becomes effective on May 28th, we have two ways to look at this. In option 1 in the documents provided, we would apply it on a go-forward basis, meaning if anyone after May 20 or on May 28th or after receives a score, that score will receive 30 months until that score expires. We have situations where we will have candidates who have already passed one or more sections that were assigned an 18-month expiration date, okay? So there's, for the candidates that are in limbo, that might mean that they have 1, 2, or 3 sections that have an 18-month expiration date, and then if they test after May 28th would have then and pass, they would have a 30-month expiration. So they may have scores that have different expiration periods. The rule, once it's effective, does not say something like beginning May 28th, anyone who receives a score is going to receive 30, their expiration date will be 30 months. So once it's effective, we could have some concern about prior candidates who've already have an expiration date assigned and whether that should actually be 30 months or should it remain at the 18 months. And so what we've discussed and we thought was prudent to bring to the board is just to make sure the board understood kind of the predicament that we're in and then how we want to move forward. So in option 1, you would only apply the 30 months on a go-forward basis. In option 2, you would take all candidates with active credit and reassign them a 30-month expiration date based on the score release date, which is part of the new rule, versus 18 months from the sit date was the previous rule. And so that's what's before you today. Maybe that got too confusing or convoluted, but those were my extra comments.
No, I think that makes a lot of sense. And in our previous discussion, it seemed that going option 1 could open up some questions in the minds of candidates going forward, as opposed to option 2 is pretty straightforward. And like you said, the rules do not say beginning on effective date or beginning May 28th or whatever. And so someone's going to look at that at some point and say, oh, I've got 30 months. And they could easily assume it's for anything that passed, it feels like. So any other discussion, questions for Wendy? And thank you, Wendy, for that explanation.
So essentially, is this giving everybody the 30 months instead of 18 months? Is that what this is basically trying to do?
That in option 2, that is for anyone with active credit. If your credit already expired, then those people would not be included. But somebody who still has active credit, that it would apply to that whole group. And to clarify, Neil and I have discussed this multiple times, and legally speaking, he doesn't have a preference. We can do either one, according to our discussions.
It seems to me that there would be a lot more inquiries and exceptions if we did the going forward one. Am I correct?
Correct. I would recommend option 2.
I have a question. I'm not on the committee, but may I ask? So option 2 would seem to be, much more simple for everyone, including candidates. So if a candidate, let's say, has passed one part with 12 months, they're 12 months into after passing that, do they get 18 months then for the rest of that part, or is it immediately 30 months for that part, even though 12 has passed? You see,
Where would the 30 start?
yeah, when does the 30 start?
It would
The date they pass that first, or whatever that part. So in other words, if you're 12 months into your 18-month term or expiration term on a part, let's say, and we pass this rule, does that part then get an additional 18 months after that, just because it equals to 30? Or do they get 30 from that day?
It would be 30 from the score release for that section.
Okay, so it just adds, okay, so total of 30 for
Yes.
any part. Okay, all right, thank you.
I think, to your question, Pam, I think we would end up getting a lot of inquiries from individuals if they still had an 18-month time frame, which in turn we'd have to suggest that they request extensions, which then we get back into, providing support and having a reason beyond their control for not, for the 18-month situation. So I would prefer, I think it's going to be easier not to go that route.
It seems that when we discussed the extensions, that we went through various scenarios, and I think we did say that the board could get very bogged down with all the exception requests, and that there would be a risk of not treating everybody exactly the same as well. So I would be in favor of the second option.
Any other questions or comments from committee members or any others? Somebody like to set forth a motion?
I move that we accept the option 2, which grants all candidates with active credit 30 months of eligibility.
I'll second the motion.
Any discussion? I guess the only question I have, should we include the phrase in there about from the score release date to Pam's motion?
I think for clarity purposes, that might be helpful.
Friendly amendment.
Do I need a new second?
David, are you willing to accept the friendly amendment?
Willing to accept. Second.
Okay, no further discussion? If not, Karen, could you call the roll?
John Griesbeck,
Aye.
Janet Booker Davis,
Aye.
Pam Church,
Aye.
David Crenshaw,
Aye.
So the motion passes, and we'll go on to the second item, which relates to draft changes to the peer review section of our rules, specifically rules under Chapter 0020-06, Peer Review Program. You've received a red line copy of the draft changes along with the rules as they read today in your packets. The draft changes as proposed would amend 5 sections. If you'll look at the page 1 of the red line at the bottom I'm referring to. And then also repeal a section, peer review results. There would be one section, I think it's number 2, related to purpose, which is not noted and therefore would remain unchanged. So we're amending 5 sections here, repealing 1 and leaving 1 unchanged. You'll note that many of the draft changes update the current processes and expectations and also update language currently used among the various stakeholders of the peer review process. The draft changes also add a requirement that firms authorize the administering entity, TSCPA, to provide objective information to the board regarding the status of firms' enrollment in peer reviews. This information is consistent with the UAA model rules agreed upon by NASBA and AICPA. As part of this process, Wendy reached out to the TSCPA and AICPA as well as NASBA for their input and feedback, and I've also reviewed various aspects of the draft changes with Wendy. I'd like to ask again Wendy to maybe provide some further insight and guide us through the draft changes from your perspective, again, to sort of aid our discussion, any questions that we might have.
Thank you, John. I know this is a fairly extensive change. I will try to go through each section, briefly explain what we're changing, and then stop and ask for any questions. But feel free to chime in at any point. As John mentioned, I basically used the model rules to draft these, so there's not a whole lot of made-up content. And the model rules are accepted by both NASBA and the AICPA. So in the definition section, I took out there the really inappropriate language related to a peer review program of the PCAOB that doesn't apply at this point, so that was removed. We added 3 definitions that felt added clarity to the remainder of the additional language added throughout the chapter. So the model rules have some more definitions, but these were the 3 that Neil and I felt were relevant to the rest of the chapter. So are there any questions regarding the definitions section of the changes? Okay. I will move on to 0020-06-.03. This was titled Review Committee. We are proposing that the review be stricken, and it is just now committee. So as a precursor to this section, this is previously referred to the committee of the board when the board had their own peer review program and administered their own program. So this was outdated language. So in this rewrite, we are attempting to refer to a peer review oversight committee. And this is a carryover from law. So the law says that the board may appoint a peer review oversight committee. And so the first three sections that we've added as new language here would be the outline of what a peer review oversight committee might look like should the board decide to enact one. We currently don't have one. But the peer review oversight committee would assist in the implementation of a program if the board chose to have their own program again, or to monitor other board-approved peer review programs. In number 2 there, we indicate the requirements of each committee member. Should the board elect to have this committee, actively licensed CPA in good standing, possess accounting, attest, and peer review experience deemed sufficient by the board. They would serve three-year terms but could be reappointed. Not be a member of the board. Any peer review oversight committee would be independent of the board, and they would report results to the board of their oversight functions. They would also sign a confidentiality agreement indicating that they would not divulge specific information to the board that would identify a firm or a reviewer at that point during the monitoring process. Number 3, the responsibilities of the committee may consist of, but are not limited to, the following. In general, monitoring approved peer review programs and considering such other matters that may be necessary for time to time. So it's a basic overview of what a peer review oversight committee would do. And again, the information being stricken is language that referred to the board's own committee when they were overseeing their own peer review program. For those of you that are not aware, prior to 2009, the board administered their own peer review program typically for firms that performed SARS type work, non-audit services. So any questions in that section before we move to the next section?
Wendy, one question just on the heading and kind of removing the word review from the topic of the section. I wondered, just to be a little bit more descriptive, would it be appropriate to just call it peer review oversight committee? That's how we describe it in subsection 1. And then that might be provide a little more context for this section.
Certainly. Just bear with me for a second. Let me make sure I make that note so I don't. Okay. Any other thoughts before we move to the next section? Okay. Okay, now I'm moving on to section 4, that's 0020-6-.04 basic requirements. So in number 1 there, we are using a lot of the same language we used in this reference currently. What we did do is remove a reference to the initial due date being August 31st. So enrollment would still be required for a firm for renewal of their permit. If they perform a test work, they'd be required to be enrolled in the program. It indicates that each firm would be that performs a test work should be covered by a peer review once every 3 years. and the report submitted to the board pursuant to that section of the rules. So again, we just removed the reference to the first peer review being due by August 31st. Number 2, firms with multiple locations may submit a single peer review report covering all locations. That is language that currently exists, but the way we rewrote this, we deleted the section and rewrote it, so there's nothing new in that language. In number 3, firm locations not providing a test services shall not be required to enroll in an approved peer review program until the issuance of the first report provided to the client. A firm shall enroll in an approved peer review program within 30 days of the issuance of the first report provided to the client. So the second half of that, of number 3 there, is the clarifying new language. So we clarified that a firm shall enroll in an approved program within 30 days of the issuance of the first report. And so that's simply to make sure that they're in the program, they receive the due date, and they are under administration by the program since they have performed a test work. Number 4, we clarify in this section that the preparation of financial statements under the statements for accounting and review services, if that's your highest level of service, then peer review is not required. And so that is new language. I'm not sure what year that they came out with that preparation standard, but it wasn't clear in our statute that that was or wasn't included under the peer review requirements. But it is part of the peer review standards. So this is a clarification in the rules so that firms know that if that's their highest level of service, a peer review is not required. Under number 5, so in this section, we are firms required to be registered with and subject to inspection by the PCAOB will also be required to have a peer review under an approved peer review program that covers the portion of the firm's practice not subject to the PCAOB permanent inspection. So that was not accurately reflected in the current peer review rules. So we clarified that there. Okay, and number 6, we are basically clarifying and adding a requirement that the firms must comply with the peer review standards and related guidance. This also references how the initial due date would be established and how often subsequent reviews would occur. So I had mentioned earlier we had removed the requirement that your first peer review occur by August 31st. This section in turn states when that first peer review is due within 18 months of when you enrolled or should have enrolled, and that subsequent reviews would be conducted every 3 years thereafter. In number 7, for good cause shown, the board may grant or renew permits for a reasonable period of time pending completion of a firm's peer review. So this is a situation, let's say there's a firm that's due for a peer review by June 30, and they are renewing their permit at the end of the year. Well, if they're in the process of having that peer review, maybe they've submitted the documents, but it hasn't made it through the committee process. This gives us the option to renew the permit given the fact that they're in the program and complying with the requirements, but don't quite have that completion letter yet. So that'll be helpful for administration reasons. In number 8, a firm that does not have offices in Tennessee and that has provided a test services as defined by the statute shall participate in approved peer review program. So there are a limited number of states that do not require peer review either for one or more levels of a test service, levels of a test work. So for example, I believe Florida only requires peer review for audit work. I definitely know they don't require it for compilations. And so if we have firms coming to this state providing a test work for clients in Tennessee, the expectation with this rewrite, this additional section is that those firms would also comply with peer review. So that is new. And that completes the suggested language for this section. So I'll stop and see if we want to take any questions there. All right, I will move on to 0020-06-.05, sponsoring organizations, programs, and standards. So the existing rule provides requirements for reviews and reviewers under the pretense of the board administering the program again. So we struck this section and we're doing a rewrite here to focus on sponsoring organizations and programs. And since the board no longer has their own program. So in the rewrite, the board shall approve peer review sponsoring organizations, programs, and standards. In number 2, we recognize the AICPA peer review program as an approved sponsoring organization along with its program and standards. And this approval applies to all administering entities, of which the Tennessee Society of CPAs is one. There are also other administering entities across the country. As a condition of the approval, the sponsoring organization is required to administer peer reviews for non-member licensees, which was one of the discussions had back when the board gave up its program to make sure there was an opportunity for non-member firms to find a place to have a peer review administered. And then the sponsoring organization would have to provide advance notice to the board if any of the administering entities were to be discontinued, so that the board would know, let's say the Tennessee Society of CPAs decided to no longer administer a program, there would be a responsibility of the AICPA to let us know that so that we could have some discussions around that. In number 3, this gives the board authority to approve other peer review sponsoring organizations other than the AICPA, which is named, if they are substantially similar to the AICPA. To be considered for approval, a sponsoring organization must submit evidence to the satisfaction of the board, and that evidence shall include standards, procedures, guidelines, oversight process, training materials, and other related documents used to administer, perform, and accept peer reviews. The board may request additional documents as needed to determine whether to grant approval. In number 4, this gives the board the authority to terminate its approval of a sponsoring organization for cause, following a notice and opportunity to appear before the board. For purposes of this requirement, cause includes but is not limited to a substantive change to the peer review program that adversely affects licensees or firms, impairs the board's ability to protect the public, or for failure to maintain an ongoing compliance with the requirements of this chapter. And that concludes the changes to this particular section, .05. So I'll stop and see if there's any questions there.
Wendy, I assume a lot of this, some of this language is from the UAA
Yes.
model rules.
Yes, almost
So-
all of it is.
We should be pretty consistent with other states, probably going forward, as they
Yes.
address some of
Yes,
this.
yes, if they adopted the model rules.
Right, gotcha.
I think what I found out is that the UAA is just a model, and each state kind of has a deviation of it based on what, I've seen at NASBA. So they do keep a running tab of those, but absolutely the model is the best way to go. And of course, Wendy, with her background and experience, has good information on that too, specifically in this area.
Okay, I'll move on to section 7, that's 0020-06-.07, peer review submission. Number 1 there just talks about the objective of why we require firms to report the results of their peer review to the board, and gives the board the authority to review documents and then may consider imposing discipline action against a reviewed firm and any individual licensee employed or contracted by the reviewed firm and involved in the attest function if the board determines a violation occurred, and that would mainly be for due professional care. And this is really the model rules for that language. We had similar language or we currently have similar language in the rule. It's just been relocated as a result of this rewrite to this section. In number 2, each firm shall submit a copy of the results of its most recently accepted peer review to the board within 30 days from the date of acceptance or completion letter, whichever is applicable. This is all currently in the rules. So the report, letter of response, acceptance letter, corrective action letter, or completion letter. So that part has been tweaked a little bit according to the updated model rules, but is the same thing that's currently required. In number 3, for peer reviews scheduled on or after June 1st of 25, the firm will be required to provide additional documents or objective information to the board within 30 days of the date of enrollment, and that is to advise the board that they're enrolled in the program and the date of their due date and the date of their first peer review. A firm representation that the firm has not performed engagement subject to peer review in the last 12 months. That's if the firm is enrolled but not performing a test work. There's probably 30 or 40 firms that are enrolled that don't perform a test work and represent annually that they are not performing a test work. C, identification of the due date of the current peer review and due date of any open corrective actions. D is date of the peer review or corrective action extension letter, including the resulting new due date. E, date of the letter acknowledging the peer review was scheduled. And F, identification of the estimated dates of the peer review commencement and presentation to a report acceptance body. So as mentioned at the beginning there of number 3, this is objective information. This is to help the board determine where a firm is within the peer review process and are they adequately complying with getting through with their peer review. Right now, this information can be provided if the firm opts into providing this information to us. What the change in this rule does is it requires firms to provide this information beginning June 1st of 2025. We selected that particular date as close to the date that this rule may be effective based on typical rulemaking processes. And the AICPA believes that they will have all the technology updated at that time as well in order to make this function, this work. In number 4, a peer review shall not be considered complete until the acceptance letter or completion letter, if applicable, is issued by the administering entity with the new due date. And then number 5, firms shall authorize the administering entity to provide the board access to the documents and objective information via a secure website process, such as the AICPA facilitated state board access, which we have access to today, and that's how we obtain the peer review report and acceptance letter as currently. And I think that completes the changes for this particular section. Are there any questions on that?
Wendy, are there any really new requirements imposed on a firm as a result of all this, other than, I guess, what you just mentioned? It goes from opt-in to a requirement, I guess?
That's the major change here.
Yeah, okay.
Wendy, how are, I guess, a firm's clients' confidentiality assured if, I guess, there's more access to the firm's information?
So the information that is new in 3 has nothing to do with the engagements looked at during a peer review. It's objective information related to the status of the peer review. So what's the due date? Have they gotten an extension? What is the extended due date? Are they performing a test work? And if not, have they attested to not completing peer review or completing a test work in the past 12 months? Identification of the commencement or presentation to the RAB. So it doesn't have anything to do with the peer review documents.
Okay, I was just looking at number 5 under section 3, where it says firm shall authorize the administering entity to provide board access to documents.
So it says to the documents and objective information. So what we could say there, we could add clarifying language there if that's confusing. We could say access to the documents and objective information in 2 and 3 above, because that's what we're referencing.
Okay. Mhm.
Is that something that you believe that should be added?
Well, yeah, I guess I'm thinking that could be good. I guess I was always a little bit concerned about if you haven't gotten authorization from your client for this peer review information to be looked at by, well, really anyone. I guess I just always had that concern about that. That type of thing, client information being out there.
I mean, nothing ever leaves the firm in terms of client information. Anything that's in the documentation really just refers to client A, B, C, or that type thing. Obviously the reviewers see financial statements of our clients, but it's never documented in terms of who was reviewed in any way, and then everything gets submitted up the line in that same format. There's nothing where the client is ever mentioned in a document that leaves the firm. It's my understanding, my experience.
I don't know. I just always had that concern.
I think for our purposes, we're not asking for any of that information. If it's not clear that we're not asking for that information, we could add that clarifying language.
Well, it just says, the board would be provided access to documents, so which could mean anything, any documents. I mean, I would think a clarification could be helpful.
And then, Wendy, I guess we have the one section that we're repealing.
Correct. The last section there, section 6, peer review results, that section is being repealed. The current rule references corrective actions the committee could impose if the board were administering its own program, which, of course, they're no longer doing, which is why this section is being suggested to be repealed.
And then in the table of contents, just prior to that section, where we, I think, had tentatively agreed to modify what was just committee to a peer review oversight committee, we would need to make that same change there.
We need to do that throughout.
Yeah.
And then the section 2, purpose, had no changes to it, and it's included in the your section of the materials as the rules currently read. But there was no reason to change anything there. Correct, Wendy? Okay.
Correct.
Are there any questions for Wendy? She went through a lot there. I was going to ask you, I don't recall when this was last updated. I mean, this is obviously a major rewrite, but, you know, a lot of us know that a lot has changed in peer review in the last 5, 10 years. And so it certainly makes a lot of sense, it seems like, from an administrative standpoint, to do this. I know it was no small effort also.
Yeah, I think the most recent change was adding the submission of the report and letter of response and acceptance letter, but we didn't tackle the rest of it because there was a rewrite of the model rules going on at that time, so we were trying to wait on that process, and actually since then have been 2 rewrites. So the last one just was completed, so I thought it was a good time to make these changes.
Mr. Chairman, I have a question. Is that okay? Sure. I'm not on the committee, but, and Wendy, that, I guess you could best answer it, but we also may need opinion from legal. And I'm sorry I didn't stop when we covered this section because I started thinking about it after you reiterated it, but it's section .04, which is on page 4 of the PDF document. And item number 8, a firm that does not have offices in Tennessee and has provided test services to Tennessee clients. My question is, what is a Tennessee client? And I'm not at all trying to pick at this, I'm just trying to think of how people might apply that rule. So if, for example, we had an entity, a holding company that was chartered in Delaware or Maryland, or maybe in a state that doesn't require peer review. Let's use that.
Yeah.
But its only asset is it owns 100% of a manufacturing company in Tennessee. Is that a Tennessee client? And I don't know the answer to that, and I don't know if that even matters, but it's just.
I'm not sure.
Greg, to clarify your question, you're asking if it's domiciled somewhere else or if it's functionally operating in Tennessee.
Correct. Right.
Well, they would be filing like a franchise and excise return, right? If they're in Tennessee. I mean, would they not? So, I mean, does that constitute a Tennessee nexus? I guess it does. I would think it would.
But the term is Tennessee client. So I don't know. Yeah. And I'm not at all trying to nitpick that. I'm just trying to think, could we have issues going forward?
I would think that if somebody's offering attestation services to this company in your hypothetical that's domiciled in Delaware, but all of their assets are in Tennessee, I mean, I think there's a pretty good argument that they're a Tennessee client. But it would be sort of unusual if all of their assets were in Tennessee, but there was no other sort of business activity in Tennessee. And I think that as soon as there's any sort of business activity in Tennessee, well, then they're probably a Tennessee client. But that would probably be like a case-by-case basis based on the specifics. But I would say in that scenario, I would think that was a Tennessee client, unless for whatever reason there was zero other business happening in Tennessee other than just holding property or assets. Does that answer your question?
It does, and I would agree with you from our perspective, but from the client's perspective, would they read that differently?
Oh, well, I'm sure they'll read it to be however is most beneficial to them. But I think generally, right, this is sort of like a common question throughout law, like especially now that so much business is happening online. And generally, we try to look at the totality of somebody's connections to a state. But I mean, I think if somebody's primarily doing business in Tennessee, even if they're not domiciled here, well, I would still call that a Tennessee client.
Laura, do you think that there's anything we should do here to clarify that? That would make it more clear or more understandable to the reader?
I think trying to define client and the roles would probably get into like a sticky situation because, like I said, it's gonna be on a case-by-case basis. I say it's gonna be on a case-by-case basis. I think it's going to be the outlier. I think very infrequently we're gonna have someone who it's not clear, if that makes sense. I think most people would understand, I'm doing the bulk of my business in Tennessee, I'm a Tennessee client. Therefore, if my CPA needs to be enrolled in peer review, if they're offering me this service. It's just like a lot of, yeah.
So help me think through this. Let's say I'm a Georgia firm, and I don't have an office in Tennessee, and I'm providing an audit for a company in Tennessee, then I have to participate in an approved peer review program. Well, if I'm doing a test work in Georgia, I would think wherever I'm doing it, I'm subject probably to their peer review, aren't I?
So this is going to be rare because most states require peer review at all levels of test work. But there are a few, and we've had cases, this board has had cases where someone has come and done, let's say, a contractor's license review, and they've come from a state that doesn't require peer review on that work. And so the idea here was to make sure they were on the same playing field as those folks that are here, those CPAs that are here in Tennessee.
So is there another way to approach this requirement? Not the Tennessee client, but somehow that if the service they're performing is not subject to review where they're located. Does that make sense?
That might be a different way of approaching it, yeah.
Would it be an easier way maybe to language around it? I'm not sure.
Well, you just have to be careful about where, like, the scope of your authority. If they don't have a license here in Tennessee, the accounting firm, right? So if they're not here in Tennessee, they're not really doing work in Tennessee, then how do we have authority to require peer review? Well, because their client is in Tennessee, right? We have to find, like, there has to be a nexus so that your scope of authority would cover them. Does that make sense?
What about if we put a firm that does not have offices in Tennessee, and then comma, and is licensed in other jurisdictions, and that has provided a test services, shall participate in
What did you want to add? Sorry.
that is licensed in another jurisdiction for, not another state, but 55 jurisdictions that offer those licenses. So if a state or jurisdiction does not participate, they would have to participate if they're doing a client in Tennessee, even though they're licensed in another state. It implies that they have to have participate in an approved peer review program. It just takes it a step further to indicate that you have to be
Yeah, I
licensed in
think-
another jurisdiction, period.
I think that's what this is requiring right
Okay.
now, but that would be a different way to phrase it, if that's, Wendy. I would defer to you on that.
I'm not quite sure I'm following. So
So he's saying that we would say if you don't have offices in Tennessee, but you are licensed in another jurisdiction, and you're providing a test work to a Tennessee client. But I think that is what this is saying, because we're saying if you're providing a test services as defined by the statute to Tennessee clients. But we could add in there, and you are licensed by another jurisdiction. Is that inaccurate? Okay.
I'm not sure that addresses the Tennessee client part, though.
Could we add language to the effect that clients with nexus in Tennessee?
I'm just wondering if we might complicate things too much, and here's the example I would offer up. Let's say you're auditing a client that's headquartered in North Carolina, And its headquarters are there, a lot of its operations are there, but they do have one manufacturing plant in Tennessee, out of several in many other states. And it may be that in that particular year, that plant was not selected for test work. In some years, it might be. And so, I would have nexus to Tennessee, but I would still argue that principally that the North Carolina requirements, whatever they are, ought to apply to the auditors of that entity if it's not based in Tennessee.
So I just want to say, I don't know if this is what Wendy was to say, if ever there was, the board would have an opportunity to review this and be able to speak on it. If, right, like if we were to get a complaint that somebody had provided a test work and they weren't involved in peer review, and it was unclear whether or not the client was a Tennessee client, that is something that would be brought to the board. So it's not as if it's not something that you guys wouldn't be able to read and make, like a common sense decision on.
Isn't this going to be rare enough to where we can deal with this on a case-by-case basis? I mean,
Yes, Rob, I would say that it's going to be rare. Because again, there's only, less than a handful of states that may not require peer review for test work, so.
I would think the stars got to really line up just right to hit that one that happened to be out of state, that kind of thing. So I just think we just deal with it on a case-by-case basis. I mean, I don't have a vote on this for this particular thing, but that's my opinion.
Rob, I think I might be inclined to agree with you, and primarily because determining nexus for a Tennessee client just seems to be a little bit broad of a scope from, what we're trying to govern, which is licensure of accounting. In the digital age where really a lot of companies have nexus in all 50 states plus territories.
Yeah, I think I agree. I think I'm on this. Yeah, that could be dealt on a case-by-case basis, seems like, if needed.
So are you all saying that this isn't needed, or you're saying that because it can be just handled when it comes up, that it's an okay language as is?
I would be okay.
Yes, that is okay language as is, yeah.
Yeah, agreed with Janet.
So we'd leave the language as is.
Mhm.
Any other questions? Any questions for Wendy or legal staff? We would like to propose a motion to approve these draft changes, I guess, subject to some clarification.
So moved.
Do we have a second?
Second.
Any further discussion?
Before we have a vote, let me clarify the changes that you
Right.
all were looking for. In the table of contents, section 3, to change to peer review oversight committee. So not only in the table of contents, but also in section 3 itself. Referencing rather than just committee, peer review oversight committee. And then in the reference of documents in section 07, number 5, when referencing documents and objective information, we're going to refer to numbers 2 and 3 above. And those are the changes I've noted.
Were there any other changes anyone noted? That's all that I had. Can we leave our motion then in second as is? Any other discussion? If not, Karen, would you call the roll?
John Griesbeck,
Aye.
Janet Booker Davis,
Aye.
Pam Church,
Aye.
David Crenshaw.
Aye.
So this motion will be recommended to the board at our meeting tomorrow with those clarifications. And again, thank you, Wendy, for your work on this, and Neil in his absence here. This is a lot of updating and very timely, I think, to go ahead and get done like this. And also appreciate the input from AICPA, Karen, TSCPA, and their work on this and their partnership with us in carrying on this very important function in the state of Tennessee. So, Mr. Chairman, that's it.
Thank you, Mr. Chairman. We're halfway through here. Do you want to take a quick break or continue on? See if we want to take a quick break, take maybe a 10-minute break and then hit into the rest of it. How's that sound? Okay, thanks.
Mr. Chairman, we are ready to go whenever you all are.
All right, so I'll just reconvene us back. Our next committee is enforcement. Kevin Monroe is our chair. And Mr. Chair.
Thank you, Mr. Chairman. So the first item we have is just an information item only. It's the case and complaint report. These items are not in the complaint or the legal report that we'll be dealing with in the committee. They're probably an early morning radar lookout here for what may be coming at us in July or thereafter. And really, by age, most of the cases that are aged are because they're in litigation monitoring or waiting for either court or regulatory types of matters. So just an informational item for our review. The next item is the legal report. We have, I think, just shy of 18. I think we've got 17 cases here, the first 9 of which are on the consent agenda, and I'll cover those at a fairly high level. And then the rest are proposed discipline cases, and we'll just briefly highlight those and then just deal with any questions that any committee members or board members have. The one overview comment that I would make, you'll see that there were several ERISA audit work cases that were referred to us in complaints by the U.S. Department of Labor relating to auditors' work on basically benefit plans that would be subject to ERISA regulation. And as we parse through those, and I worked with Neil on those in terms of review, there are, although the offense is generally similar across the cases, the recommended disciplines do differ, in part because of either mitigating factors or, in a couple of cases, aggravating factors where the CPA involved has had prior recent discipline, sometimes including on ERISA cases. So you'll see those differentiated as we go through the proposed discipline. So beginning with the consent agenda items, the first such case is an ERISA DOL referral. The recommended discipline is for letter of warning. In these cases, essentially, what had happened is 2 or 3 years ago, the language for the auditor's report referencing to ERISA with respect to that report changed. And in nearly all of these DOL-related cases that we'll be dealing with today, the auditors failed to pick up on that, and they issued an audit report that did not reflect the appropriate updated language with respect to those reports. And so the DOL caught that, they flagged it. The auditors had to resubmit their reports to reflect the appropriate language, and in each case, the DOL accepted that resubmitted report. In this particular case, the respondent cooperated, and actually they voluntarily, without us recommending, completed additional CPE, 4-hour CPE courses relating to ERISA or employee benefit plan audits. So the recommendation here is to issue a letter of warning. The second item on the case is a due care complaint. And basically what we have is the complainant alleged that the respondent didn't maintain good communication with the complainant and didn't complete taxes by a deadline. There were issues communicating between the complainant and the respondent. As it turned out upon investigation, there never really was an engagement letter with the respondent. Additionally, the complainant never paid for any services, and so the recommendation here is simply to close. The third case is involving a complaint about the use of the CPA's designation. The respondent denied that, and during the investigation, there was no evidence suggesting that the respondent ever did advertise or solicit services as a CPA or use the CPA designation other than the bare, unsupported allegation of the complainant. So this council recommends closure on this one. The fourth case basically is in the category of operating without a firm permit. In this particular case, the respondent was operating without a firm permit while using the term accounting in the respondent's business name and list of services. Upon investigation, it was determined that the respondent was not a CPA, and the respondent was not well informed about the matters with respect to their use of appropriate terminology. They indicated that they were a tax preparation business and registered with the IRS. The respondent, during the investigation, corrected for things by changing the name of the business so that it no longer contained the term accounting, and also signed an affidavit indicating as such. So the recommendation here is to close based on the fact that upon notification of the complaint, the respondent quickly addressed the issue. The next case, item 5, is a case concerning services paid for but not provided. Also, this affects case 6, so I'll address both of these at the same time. Both of these cases are additional complaints relating to a matter that the board addressed, I believe, 2 meetings ago, whereby the board approved a recommended penalty of permanent revocation of license and a consent order related thereto. That consent order had been executed and that license has been permanently revoked. So for both cases 5 and 6, these complaints relate to that same individual who now is no longer a licensee and may never be a licensee. And so really from a jurisdictional standpoint, there's nothing more to do here, and so the recommendation for these 2 is closure. That's both items 5 and 6 in the consent agenda. For item 7, basically it's a due care case, but it really boils down to a fee dispute. And in this case, we do not deal with billing issues. That's out of our jurisdiction, and so the recommendation here is to close. Item 8 is the relating to the use of the term accounting without a permit. And in this particular case, the respondent indicated that they were unaware of the statute. They advised they were going to change the name of their business and were undergoing that change. They provided an operating agreement disclosing the change in the name of the business, which removed the term accounting. And due to that and the documentation provided, the staff recommendation is to have this case be closed. The last consent item is relating to the use of the CPA designation without a license. In this particular case, we had an anonymous complaint. The respondent was not a CPA, and the respondent denied that she ever represented herself as a CPA, and provided, paperwork from her employer documenting her board engagement and so forth. She did use the title of Master in Professional Accounting in her signature block, and had used that for quite some time, and indicated afterwards, after talking with our investigator, that she would remove that from her signature block title so that there's no confusion at all. And really, due to lack of any evidence to substantiate a true violation, the recommendation here is closure. So those are the 9 items on the consent agenda. Let me stop there and just seek if there are any questions or comments from committee or board members on any of the consent agenda items.
Mr. Chairman, with respect to the ERISA cases, of which number 1 is an ERISA case, I wonder if a CPA firm is doing employee benefit plan audits and doesn't know what the current requirements are for a report, is 4 hours or 8 hours, or and we have different levels of hours we're requesting, is that enough? And I did very little audit work during my career, but I do know employee benefit plans can be complex, and they've got their own sets of rules. So if a firm does not know what audit report to issue, is there a more pervasive underlying issue with the firm auditing benefit plans? And therefore, is more CPE needed, or do they need to join the audit Center for Audit Quality Control, the AICPA? And I think the AICPA has employee benefits.
They do.
Section 2. So, and we can vote, and I can vote for number 1 just fine, but I wonder overall if these firms need to be doing ERISA audits without more training.
Yeah, I think that's a very good question, and maybe to provide some additional context, and Duke, you may also chime in as well. The question that I had when I was initially reviewing these cases was, well, if they can't get the opinion right, what else is wrong, and was that the subject of any DOL, review? And the DOL can and does go in and perform on occasion as needed actual reviews of underlying audit work papers. And in these cases that were referred to us, the item that the DOL chose to challenge was the inappropriate use of an old version of a report. And once they determined that the report issue had been remedied, it was our understanding that they did not go back in and seek to further, examine, review audit work papers in those cases. So we don't really have any evidentiary matter yet to know in these cases if there was something going on in addition below the surface. I mean, I would think there might have been, but we don't know that. And the investigation didn't really have the scope to address that. We were looking at the complaint that had been filed, which was revolving around the report. Now, in some cases, I think we'll see as we get into the proposed discipline area, not only are we recommending training, but we are also recommending that prior to the commencement of further ERISA-related benefit plan work, they have to notify the board. Not in every instance here, but I believe there are 1 or 2 of these cases where they have to notify the board if they intend to continue to do audits of benefit plans subject to ERISA on a go-forward basis. And Wendy, I guess I'll open up to you as well if you have a perspective on this.
I think we chose, on the individuals that we chose a notification and to provide continuing education, it was on the couple of firms that said they weren't going to do ERISA work anymore. And so that was, when we took that approach, that was why, because they claim they were testing the fact they weren't going to do this work anymore. In case 1, I think the expectation is they're going to continue to do this work. So.
And they had already voluntarily completed
Correct.
some employee benefit plan training.
Correct.
Yeah. So, the DOL has, and we were, as I can remember when I was in active practice and I would go to, quality control meetings because I was a quality control partner in my practice unit. We would actually have members of the DOL come to us and basically say, these are the common, pitfalls that we're seeing in audits, and you guys need to develop your training and your audit plans to address them. And, I know that for firms that do peer review, that do benefit plan audits, they are subject to specific peer review. So that is hopefully what we're going to have to rely on to catch some of this. And one of the possible things that we could do is make it more of a point of emphasis in our Tennessee state-specific ethics training to basically, where we kind of highlight common areas of complaints that, this is an area of focus, and that might be something to consider.
I think that's good. I had the opportunity to serve 6 years on the AICPA Joint Trial Board, and a good number of the cases in which I was involved were DOL,
Yeah.
employee benefit plan cases. So the DOL certainly watches this, but
They do. It's subject to peer review, but we have a lot of firms that think benefit plan audits are just off busy season peak work that don't require a lot of effort. And that's a concern. Thank you. Any further questions on any of the consent cases? If not, I'd request a motion to approve the recommended discipline, or, well, not discipline, but to approve the recommendations with respect to the items on the consent agenda.
I so move.
Thank you. Is there a second?
Second.
Thank you. Is there any further discussion? Okay. Karen, will you call the roll?
Kevin Monroe,
Aye.
David Crenshaw,
Aye.
Greg Gilbert,
Aye.
Rob Vance,
Aye.
Okay, that motion passes. So now we're going to go to the cases that have proposed discipline attached to them in terms of disciplinary recommendations. The first case is an ERISA case. We've talked a little bit about the history. In this particular case, the recommendation is for a formal hearing with authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,000, and further require the respondent to provide proof of completion of 8 hours of ERISA-specific audit training for any partners working on ERISA audits, and to be completed within 90 calendar days of the execution of the consent order. This would represent effectively standard discipline plus the CPE hours for ERISA-specific training. What we'll do, if you're comfortable with this, is I'll go through the cases, we'll deal with any questions that we have, and then we'll have one motion to deal with the recommendations. If we want to separate any of these out, we can do that and vote separately. The next item also is an ERISA case, that's item 11. In both items 10 and 11, there is some prior year history of complaints. And in this particular case for item 11, there's rather some significant complaint history that is relatively recent, with one complaint being closed with a $6,000 civil penalty for offering a test services without a valid firm permit. In this particular case, subject to the same DOL flagging of using the inappropriate report. And the recommendation here is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,000. And to further require the respondent to agree that should the respondent elect to perform audit work subject to ERISA at any point in the future, they must comply with the following. 1, notify the board of such election prior to performing any such work. 2, each owner responsible for ERISA audit work shall provide proof of completion of 8 hours of ERISA-specific CPE training prior to the performing of any such work. I think this was really considering the aggregating factors of past disciplinary history here. And so that's why this is not the standard discipline that would flow from the matrix.
Are we going to discuss these as, at the end?
We can
I'm
discuss
sorry.
these at the end, but if you'd prefer, we can discuss them as we go through them. That's just fine.
I just wanted to ask about, this one was fairly egregious because of the two priors,
Yeah.
if you will. But how do we know, when they say that they're not going to do ERISA work anymore, how do we know that? Or can we know that? I mean, I guess we don't unless they just, the DOL audits them again, I guess. I mean, is that a correct statement?
I think that's correct. I think that you could make it part of the consent order, meaning and Taylor, you can help me with this, but in the order section, you could say something like agrees not to perform ERISA work, and then if firm chooses to perform an ERISA work, then they do these things. So they'd be signing off. Not only did they tell Duke that, but then it becomes part of the order as well. But yeah, you don't know.
I think we should do that because they've been performing ERISA work for a long time, apparently. And for them to just turn it off like that
Well,
doesn't seem likely.
The other two complaints were not related to
they're
ERISA work.
not?
So they're simply related to performing audit work without a valid permit.
Okay. Oh, okay. Thank you. That's all I need to know.
Okay.
Oh, I'm sorry. Yes, I'm good.
Okay, all
Thank
right.
you.
So we'll go on to item 12. In this particular case, the complaint basically involves a referral from the Mississippi Board of Accountancy after the respondent prepared an audit report that was presented to the state of Mississippi, but the respondent was not a CPA and did not have a firm permit and did not have an accounting degree. The respondent did not deny the allegation and admitted to providing the audit report without a CPA license and without a firm permit. We have an aggregating factor in that the respondent committed these violations while not possessing the basic minimum qualifications to sit for a CPA exam. There was a mitigating factor in that the respondent, when made aware of the complaint, admitted to issuing the audit report readily, and counsel is recommending a civil penalty of $2,000, $1,000 for issuing an attest service without a firm permit, and $1,000 for using the CPA designation without a CPA license. So the formal discipline recommended is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $2,000. Any questions or comments on that one?
I was wondering, why was this referred from Mississippi Board? It says he was unlicensed. Was that?
Yeah, that's a good question. I'm assuming he's domiciled in Tennessee, but either Duke or Wendy or Taylor, you want to address that?
Yeah, he lives in Tennessee.
Okay.
So this was an unlicensed person doing work in Mississippi?
Doing work here, and I think it was provided to the Mississippi Board of Licensing Contractors or some sort of Mississippi government entity.
So I think the answer, the way I took from that is that because he's domiciled in Tennessee, and since he's not licensed in either jurisdiction, that Mississippi opted to go ahead and refer that to us.
Since he lives here.
Yeah.
Mm-hmm.
Mr. Chairman, for number 13, the next one, they've received some new information here recently, so they're asking if we can skip over that one.
Certainly.
And kind of go back to that.
Okay.
Is that correct, Taylor?
Yeah, sorry, we just received something pertaining to that, so I'm reviewing it right now just to see if there's any more information that needs to be added to the summary that we can discuss. So yeah, if you could just move on to 14, then we can come back
Okay,
around.
we'll pass on item 13 for now and proceed on to item 14. Item 14 is another one of our ERISA complaints. There is no prior history with respect to this one, but again, similar to the others, the incorrect report was utilized. Let me just make sure here. Well, there are some complications actually to this one, so let's kind of review this in a little bit more detail. So the board complaint was based on a referral from the DOL. They were reviewing a report pertaining to a 401k plan, and the report was not presented in accordance with GAS. They used essentially the old report language. And in addition, there were some issues revolving or relating to the Form 5500, which was managed by a third-party administrator. And the respondent stated that its role was limited to conducting the 401k audit and providing the report to the third-party administrator. There was a mismatch in between the auditor's information in Form 5500 and that in the audit report, and that was attributed to the third-party administrator in updating the respondent's information. Respondent recognized an error in their 2021 401k audit report as well. And so the respondent emailed the assigned investigator and advised that an amended audit report had been resubmitted to the client. It had also been determined here that the respondent had not been registered for peer review when he issued the audit report. The respondent advised that they no longer provide audit services and of course, therefore, are not going to register for peer review going forward. And so in this particular case, when we get to the recommendation, we have a total $4,000 civil penalty, $3,000 for peer review violations involving an audit, and then $1,000 for also a misrepresentation on the permit renewal application. So the recommendation here is to authorize a formal hearing with the authority to settle via a consent order upon the respondent's payment of a civil penalty in the amount of $4,000. Further, require respondent to agree that, should respondent elect to perform any attest work at any point in the future, they must comply with the following. 1, notify the board of such election prior to performing any such work. And 2, if any such work includes ERISA-related audit work, each owner responsible for ERISA audit work shall provide proof of completion of 8 hours of ERISA-specific CPE prior to performing any such work. So we basically have a peer review violation, and we have the misrepresentation on a permit renewal application that are leading to the recommended $4,000 civil penalty. Any questions on this one?
In the recommendation, should we include a requirement to be enrolled in a peer review program if they're gonna perform attest services?
Yeah, Janet, I think the reason primarily that it was not originally included in this case is because the respondent has stated that they are no longer going to be performing attest services. So we did state that if they change their mind and agree to start doing that, then they need to notify us in advance. But in this particular case.
Yeah, it didn't say that they should also be enrolled in a peer review program and/or have had a peer review and get a passing grade on that peer review.
Also, I think Duke
I
had
mean,
an additional comment.
Yeah, so,
pertaining-
I'm sorry, I didn't mean to interrupt you.
Sorry, I thought you were done, sorry.
So the representations that were made to us is they were no longer going to be doing any attest work. So I just checked the website again today, and it's still advertising audit work on the website. So those representations that they said they weren't going to do about 6 weeks ago, at least it hasn't changed in terms of soliciting of services on their website.
Well, if that's the case, I would sure think a follow-up would be in order to them to basically say, you represented this, and you're still advertising for services.
That's correct, yes.
And so I would hope that would be something that we need to follow up on.
And I guess my point was that in the recommendation, they could notify the board that they will start performing attest services, but there's no requirement that they be in a peer review program in the recommendation if they're gonna perform attest services in the future.
Let me ask, so one question or one thought that occurs to me on that, Janet, is that if they resumed the performance of a test work, under the existing rules, whether it's in the recommendation or not, they would have to enroll in peer review. They're required to do that, are they not?
Yeah, and I think we had this discussion, and that was one of the things during our discussions. We thought, well, do we add it or do we not? And we thought, well, it's a requirement anyway. So we elected not to, but it can't hurt anything to add it. But you're correct, Kevin. If they choose to do any kind of a test work or they just choose to do ERISA, they need to enroll in, they're required in other sections of the law and the rules to enroll in peer review.
Right, it is a requirement. I agree with that, but to me, it wouldn't hurt to include that in our recommendation, that that's part of what they would need to do or have done.
Okay, so maybe one way of articulating that, where we've got the two recommendations here, notifying the Board of Election prior to performing any such work, and if it involves ERISA, getting the appropriate 8 hours of training. I guess we could add a third section, and basically comply with appropriate peer review requirements.
Yes, yes.
So we'll add
Yeah, one other, yeah, I don't, well, this may relate to this one as well, but this DOL audits, there seems to have been, I guess, a change in the report format, which seems like it's resulting in some of these companies issuing reports that are not in compliance with a new standard. And in our recommendations, I think in all of these that involve that report non-compliance, it seems like it would be good if we recommended that these audit firms have some change in their procedure that ensures when there's a new requirement for the audit or audit report, that there's a way to, one, detect that those new requirements are not in their practices, and to get that updated on a timely basis to prevent these types of things. Does that make sense?
I think it makes sense. I'm not sure how easy it would be for us to enforce that. And I guess I think really maybe we got at it indirectly by requiring the ERISA-specific or employee benefit plan-specific audit training. I think that's what we were trying to get at. The other item of note is that in each case, the DOL made each of these firms resubmit the corrected audit report that reflected the updated opinion. And that was required to be done not by us as the Board of Accountancy, but by the Department of Labor in the context of their discipline with respect to these respondents. And so I think
I just thought it might have been, it may be good to include that in our, specifically in our recommendation as a preventive measure, because I mean they should have ways to detect and include updates to their practices anyway. But I guess there's some firms who don't.
well, clearly, based on our discipline list this meeting, there are some that didn't, and hopefully now
Yeah,
they're
right.
wiser for it. I do think, though, that the DOL basically did a mass review of all of the submissions that they received, and one of the gate checks was, did they submit the correct opinion that has, at least on the surface, the correct language? And if they didn't, they got flagged. And I think, Duke, you'd indicated that not only did our board receive, X number of referrals, there were referrals that were, sent to other state boards as well.
Oh, that's correct. So that's exactly, as the chairman said it, they just basically flagged just the audit report itself. And then they sent referrals out to all various boards and the AICPA as well. So they got inundated as well.
Okay, well, hopefully the training would help with that type of prevention measure.
So that is the hope. To kind of just circle back on the revised recommendation that we'll be asking for the committee members to vote on, it will read as it states, and then we'll add a third element to this, which is after the second element, it will read comply with appropriate peer review requirements.
Mr. Chairman, I'm not on that committee, but do you think that we need something there that says that they would agree to cease advertising for test services as long as they're not electing to perform them?
Well, I think that's a fair point.
And then maybe insert that at the end of the penalty period, and then say furthermore that the respondent would agree to cease advertising for any test services while not electing to perform attestation services.
Okay.
And then that would then go into, however, if if respondents believes that that should respondent elect to perform, and then that continues on in that kind of statement there. That way, at least he'll take it down from the website.
Right.
I'm just jotting down some language for us to consider here.
Okay.
So one of the things to consider, I know we just talked about the revision to the peer review rules, but we make a statement in there that in the revisions that someone would be required to enroll in the program within 30 days of accepting their first engagement. So I think that creates a little bit of a gray area in the offering side of things about whether you need to be enrolled or not. So we either may need to think about that in this context, but also think about it in the rules context. Is the intent of the board to, if someone's offering or advertising the services, does someone need to be enrolled or only upon issuing or engaging in offering those services?
I think I was getting at the fact that this firm has had problems in the past, and they seem not to be doing a very good job with it.
Right.
That's specific to this firm
Yeah.
as an agreement.
Right, and I agree with that. I guess I just want to make sure we have authority to ask the firm to do something specific.
Well, read number 3 again, if you would, please.
So what I was proposing, what I was proposing on the peer review aspect of this discipline language was to comply with appropriate peer review requirements, which I thought was broad enough to basically say if a peer review applies based on what you're doing, you need to follow the appropriate requirements.
I think that hits both those points.
I agree, and I guess I thought I heard Andy suggesting that something different about the offering side of it, that because it's on his website saying he does a test work.
The advertising of those services that he's agreed not now to perform.
Right.
So what I have in terms of trying to address that concern, Mr. Chairman, is after, it would basically say it would occur before the sentence that says further require respondent to agree that should respondent elect to perform any test work. It would be, the sentence would be the respondent will cease advertising for attest services during the period in which respondent is not engaged in the performance of attest services. And then it would read further require respondent to agree that should the respondent elect to perform any attest work as it's currently written.
And within a consent order, which was what's sent to them, it lays out, here's what you violated, you're agreeing to not do this again. So inherently within the consent order, they're agreeing to not kind of make the same violation again and to comply with all requirements. So it's up to you if you guys want to really break it down that much to include these regulations within the recommendation, as well as that kind of stuff will be covered in the consent order anyhow.
Okay.
So it's been 6 weeks ago, he told us that he would not do any, but he's still advertising to do it on his website.
Well, it's actually been longer since that communication. It was a meeting that we had that we checked it, and it was on the website 6 weeks ago, and then it's still on there as of now. So the representation that was made to me was probably about 10 weeks ago.
But did you specifically tell him to take it down from the website?
I don't tell him
Well,
to do
I'm-
anything. It was
all
just
right.
told me that they were not, and by the way, it was done via email. This person preferred email communication, and they said, so it's documented, they said they were no longer going to be doing a test work.
But they didn't say, and we'll take it off the website. They
No.
didn't volunteer that, so maybe, depending on how sophisticated they are with websites, maybe they don't even know it's there. Or they don't update their website enough to really realize what
It's
they're doing.
possible, yeah.
I mean, maybe you could inform them that that's a
Sure.
problem. Thank you.
Yeah, I guess to that end, maybe the suggestion would be, based, Taylor, on your comments about the communication that goes out with the consent order, is that, y'all would notify them and basically say, hey, as we note as we send you this consent order that you're still advertising for attest services, although you represented to us that you were no longer performing them.
And that, when I sent out the consent order, that's something I can make clear to them, is that in reviewing the case, we noticed it was still up on your website as available. that you're so offering this to be hired to do this kind of work. And going forward, if you're not advising by all requirements to perform that kind of work, it's going to be another issue and a potential another complaint.
So, Mr. Chairman, would you be comfortable with that kind of administrative handling of that concern?
Yes, sir.
Okay. So what we'll do is, the only modification currently being proposed to this recommendation is to add item 3, comply with appropriate peer review requirements.
Mr. Chairman?
Yes.
First of all, thank you for chairing this committee. I've had the opportunity to sit in your chair, and I know that's very difficult at times when we're throwing darts in different directions. But
Throw away.
so this is a question. I know that you and Mr. Griesbach have spent a lot of your careers doing audits, and others have too. So this is just a question from a non-auditor. Do these cases rise to the level of where we should require a pre-issuance review by an independent CPA firm? Do they rise to that level, the violations?
I'll chime in, and John, feel free on your
I
basis.
guess my initial thought would be that, the first line of defense would be their quality control standards process in their own firm, which would require potentially another partner reviewing or going outside for an issuance review or potentially, and then just peer review in itself. But, how many distinct cases were there from DOL this time? 3, 4?
I think it was more like 6 or 7.
Yeah. So
I
they
believe it was
obviously-
5, specifically for our state.
So,
5.
this problem is not just a one-off. A lot of firms stumbled on this, it sounds like, in implementing this, and not to excuse what they've done, but I'm not sure I'd go that route, but or maybe
Thank
just
you.
rely on their own internal process and peer review.
Yeah, I think in this case, what happened is they just didn't pick up on the fact that a new report format was needed. And they, basically the DOL, to their credit, did, because they were probably just, reading every report or having AI or some entity or software read it for them, and catching them on a 100% basis, presumably. And so for here, I'm not as worried about that as long as they did the underlying audit work, which we just don't have any evidence one way or the other. But if through peer review or through other mechanisms, DOL referrals on other matters, I think that would be a justifiable option. Any other items, any other questions on item 14 before we move on to item 15? The next item, 15, is actually based on a complaint filed with the board. There was a self-report by the respondent stating that his firm had reached a settlement with the SEC, and a consent order was issued by the SEC alleging that the respondent, in connection with an audit of a Louisiana governmental entity's financial statements, failed to perform the audit in accordance with GAS. The complainant alleged that the governmental entity unknowingly used the auditor's report to sell $120 million worth of bonds to an investor in March of 2020. The respondent did confirm that they did conduct the audit in question, and normally the respondent indicated that they do not normally conduct audits of public companies that practice before the SEC, and that the client had used the report with a public debt offering that he had no knowledge of. Then there's a number of other facts here. One of the aggregating factors is that the respondent failed to identify an overstatement of revenues and expenses. And although that did not change the overall financial position of the entity, they did have to have financial statements restated in this matter due to the misstatement. The respondent did self-report the settlement with the SEC to the board and was generally cooperative during the investigation. They have never practiced before the SEC, and they do not intend to practice before the SEC in the future. In this particular case, the SEC agreed to a settlement where a respondent neither admitted nor denied the allegations, but agreed to pay a fine of $30,000 fine, but $44,000 total due to disgorgement of fees and interest. The entity was also suspended from practicing before the SEC for a period of 3 years. In this particular case, the recommendation is for a formal hearing with the authority to settle via consent order upon the respondent's payment of civil penalty in the amount of $1,000. Any questions or comments on that particular case? Not, we'll go to item number 16.
Mr. Chairman, I believe
Yes.
that last one was item 16, and the next one coming up will be item 17.
Oh, I'm sorry.
Yeah, we skipped 13, just because of an issue
Yep.
that came.
That
So,
was 15.
Oh,
so I think,
The whole time we've been talking about 14.
gotcha. Okay. So sorry, never mind.
no problem, okay. We'll go on to item 16, and we will come back to item 13. If I don't remember, just please remind me. So item 16 in our read-ahead is with respect to a complaint that was filed based on the audit of the respondent's continuing education credits for 2021-2022. The respondent was notified of the audit and given until August 21 of 2023 to provide proof of CPE. Based upon the insufficient CPE information the respondent provided, the respondent received another letter notifying him of several deficiencies. They included lack of proof of completing the 80 hours of CPE, failing to earn 40 hours in technical subjects, and failing to earn at least 20 hours in 2022, and failing to complete at least 2 credit hours in a board-approved Tennessee state-specific ethics course. There were mitigating factors that included that the respondent expressed remorse, and respondent remedied his deficient CPE by the end of December of 2023, but stated that he was unsure how and when any notification from the board would occur regarding penalty hours. It appeared that the notification went to the respondent's spam folder, and so the respondent was unaware of the penalty hours that were assessed. Once he acknowledged notification, he completed the required CPE within 1 month. Also, from a mitigating factor, the respondent went through a traumatic personal tragedy in March of 2022. An aggregating factor is that the respondent answered numerous questions incorrectly while renewing his license. So the recommendation is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,000 and respondent's agreement to complete the National Association of State Boards of Accountancy ethics course within 90 days of execution of the consent order. Any comments or questions with respect to this case? If not, we'll
I had
proceed.
a-
Yes, Janet, go ahead.
Oh, I was, this blank page that was submitted with the renewal, was that an accident, or I guess I was just wondering what was up with that. Any more information about what that was about?
No, no detail was provided on what the blank page was. I don't think it was, I couldn't really determine that was done in some sort of deceitful way. It's just a blank page got uploaded.
Okay, and they had completed all the required CPE?
Yes, by the end of December of 23.
Yes, okay. Okay, thanks.
We'll proceed to the final case and then circle back to case item number 13. So on item 17, this complaint is also relating to DOL and ERISA audit, so it's the same type of violation. They used the inappropriate audit report that had not been updated. There were some mitigating factors in that the respondent quickly remedied the deficiency when made aware of the compliance issues. They submitted the new audit report to the DOL. The recommendation here is for authorization of a formal hearing with the authority to settle via consent order upon the respondent's agreement to provide proof of completion of 4 hours of ERISA-specific audit training for any partners working on ERISA audits to be completed within 90 calendar days of execution of the consent order. Any further questions or comments on this one? Okay, we will circle back to item 13, and Taylor, I'll turn it over to you.
Yeah, so We had received some updated information, and Wendy and I discussed, and we think it might be best just to push this one off till tomorrow so that the three of us can kind of look a little bit more into the information we received and see if there's any changes in recommendation.
Okay, so we will just address any recommendation on this one tomorrow as a full board?
Correct,
And
yeah.
we'll not address that in our committee
Yeah,
recommendations
so yeah, we'll
today.
kind of just skip this one out on the voting.
All right, that sounds fine. So essentially, let me see, I just want to make sure I'm properly identifying the case where we made edits here. That was item 14. So there, in terms of the edits to the read-ahead, we added a third compliance matter to the recommendation, which is that they will need to comply with appropriate peer review requirements. Omitting item number 13, we'll save that for tomorrow. So for items 10 through 12 and 14 through 17, 14 inclusive of that additional requirement associated with peer review, is there a motion to support the recommended discipline for those cases?
I so move.
We have a motion. Is there a second?
Second.
We have a second. Is there any further question or discussion on any of the cases? Karen, will you call the roll, please?
Kevin Monroe,
Aye.
David Crenshaw,
Aye.
Greg Gilbert,
Aye.
Rob Vance.
Aye.
Motion passes. Mr. Chairman, that concludes the report of the Enforcement Committee.
Thank you, Mr. Chairman. Great job. Next, we're going to the Executive Committee, and we'll start off with travel and get Wendy to update us on the travel report.
Thank you, Mr. Chairman. Give me 1 second. Let me get this in front of me. So the travel document provided to you all just represents travel for Duke and I since our last meeting. Includes an outreach event for myself in February, and then in board meetings for Duke. And then in March, Duke and I both attended NASBA's Executive Director and Legal Conference, and so those expenses are noted there as well.
All right. And everybody got a copy of the financial statements year to date, and just kind of go through and look over that. Any comments on that? Wendy? We've got.
Yeah, I'll walk through this quickly. These are for the FY24 year-to-date stats as of February of the current year. As a reminder, the fiscal year is July 1st through June 30. These are as of February of this year. So total revenues less the state regulatory fee are at $946,500, and expenses are currently at $712,463. Leaves us in the positive at $234,037. Of course, we have seen most of our revenue so far in the current fiscal year, so that number will dwindle. As you can see, we are a little bit behind the prior year in that net revenue to reserves number, but I do feel like we're doing pretty well. I'll kind of highlight the substantial differences. Revenue, it does appear to be up slightly to the prior year, although the increase is really attributed to our case and complaint. We had a large case last year that we received civil penalty on, and so the licensing revenue in general is flat to the prior year. So as I've mentioned in some of our prior meetings, the salaries line item you will see is at a 24% positive over the prior year, and that is attributed to the statewide enhanced salary restructure that was done through a few stages last year. And so that was something we had not necessarily planned for, so most of our increases are in that particular line item. That is also true in the longevity compensation item. that line item typically includes those individuals eligible for longevity compensation, but it also includes some pay for performance rewards, which is basically the bonus plan, and any money for individuals at the salary cap, which includes my position. So that's why that particular line item is showing at a substantial increase over the prior year. As far as travel goes, you'll see that we are behind the prior year. We had less people attend NASBA's annual meeting in the fall, and then the regional meeting from last year, NASBA's regional meeting, those expenses actually fell in the prior year rather than in the current year. So that's why our numbers are looking fairly good on travel for the current year. Let's see, the other substantial difference there, I think, is the computer-related items. You'll see last year we were only at $246, and this year we're showing an expense of $4,400 with a budget of only $1,000 for that line item. This particular line item refers to technology-related purchases outside of our computer purchases. But they have decided that our ticketing system called Zendesk, we are charged annually for that. It has fallen in cost backs in prior years, but they have chosen now to create a direct expense for our direct purchase there and for the licenses that we hold in that system. So that's a little bit of change from the past. And then year-end cost backs, we look good compared to the prior year. Our legal fees are about half of that line item, and those are stabilizing a bit. So I think we're doing well in the cost back area. So I'm happy to take any questions if there's anything outside of those comments or including those comments that you have questions about.
Any questions for Wendy? All right, seeing none. I think this is an approval item. Is that correct for the, or are we just, it's a required presentation because I didn't see an action item.
Yeah, we typically have not.
Okay.
We approve a budget, but we have not necessarily approved the updates.
Okay, all right. And that'll bring us then to the end of the executive committee. And we have our public comment period. Has anybody signed up for any comments in our public comment period?
Mr. Chairman, I have not seen any
Okay.
comments.
Any other thing to be brought forth today, or? Looks like we're going to give some time back. So with that, do I have a motion to adjourn?
So moved.
All right, and a second? Second. Okay, well then we will reconvene tomorrow morning at 8:30 for the board meeting. I assume that breakfast will be provided at 7:30 on, so I look forward to seeing everybody in the morning, and safe travels.
Okay.